la Cour.
Oui. Oui. Merci, chers membres du public. Merci, chers auditeurs. Merci, membres de la Cour, et merci aux honorables collègues juges. Aujourd'hui, 25 juin 2021, la Cour va prononcer ses dernières décisions et je vais donner la parole au greffier afin qu'il nous indique les décisions qui vont être à cette occasion-ci délivrées. Docteur Renaud, vous avez la parole.
Thank you, Lord President. Good morning. This is a public sitting for delivery of judgments in 8 matters. The first group of cases will involve delivery of judgment in 4 matters. That is application 010-2015, Amir Ramadhani versus United Republic of Tanzania. Application 032 of 2015, Kijiji Isiaga versus United Republic of Tanzania. Application 008-2016, Masood Rajabu versus United Republic of Tanzania. And application 023 of 2016, Yahaya Zumo Makame and others versus United Republic of Tanzania. So this is the first group of judgments that will be delivered, and thereafter the court will be reconstituted for the next 4 judgments. I thank you, Honorable President.
Merci, chers membres du greffe. Je vais immédiatement donner la parole à l'honorable juge Ben Saoula, afin que celle-ci nous donne lecture de la décision Amiri Ramadhani.
Monsieur le Président, je pense qu'il y a un changement. C'est le juge Dean qui va lire l'arrêt. Il y a eu un changement ce matin.
Alors, l'information que j'ai eue semble être contradictoire, mais quand cela nous tienne, je donne la parole au juge doyen, au juge Kyoko. Vous avez la parole.
Yeah, thank you very much, Honorable President, Honorable Judges, registry interpreters, and members of the public and the parties. On behalf of the court, I'll be delivering the judgment in the matter of Amir Ramadhani versus United Republic of Tanzania, application number 010 of 2015, which is a judgment on reparations. The court composed of Blaise Chikaya, Vice President, Ben Kyoko, Rafa Benashu, Suzanne Menge, Madam Marie-Therese Mkamuliza, Tujilan R. Chizumila, Shafika Ben Saula, Stella I. Anukam, Dumisa B. Sebeza, Modibo Sako, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9.2 of the Rules of Court, Justice Imani D. Aboud, President of the Court, and a national of Tanzania did not hear the application. Brief background of the matter. In his application filed on 11 May 2015, Mr. Amir Ramadani alleged that his rights to a fair trial, including the right to free legal assistance, had been violated by the United Republic of Tanzania in the course of domestic proceedings. I will skip some paragraphs. I'll now go to paragraph 4. Subject of the application. On 30th July 2018, the applicant filed his written submission on reparations following the judgment on the merits rendered by this court on 11 May 2018. In the said judgment, the court unanimously found that the respondent state violated the applicant's right to be provided with free legal assistance protected under Article 71C of the African Charter on Human and People's Rights, hereinafter referred to as the Charter. Prayers of the parties. The applicant prays the court to grant monetary reparations as follows: US $20,000 to the applicant as a direct victim for moral damage, US $15,000 to the applicant's wife and mother of his 2 children, Mariam Ramadan Juma, as an indirect victim for the moral prejudice suffers, US $2,000 to the applicant's brother, Mr. Hussein Ramadani, as an indirect victim for the moral prejudice suffered, $2,000 to the applicant's brother, Mr. Isa Ramadani, as an indirect victim for the moral prejudice suffers, $2,000 to the applicant's sister, Ms. Asia Ramadani, as an indirect victim for the moral prejudice suffered, US $2,000 to the applicant's wife, Mariam Ramadan Juma, for the material prejudice suffered as a wife, US $20,000 to the applicant for legal fees, and US $1,600 for expenses incurred. The applicant further praised the court to order the respondent state to guarantee non-repetition of the violations and to report to the court every 6 months until they satisfy the orders on reparations, and 3, publish in the National Gazette the judgment on the merits within 1 month of delivery of the present judgment as a measure of satisfaction. The respondent state praised the court to order that the judgment of the court on the merits of the matter is sufficient reparation. 2, the applicant's claim for reparations is dismissed in its entirety with costs. And 3, the respondent state is granted any other relief the court may deem fit. Article 27 of the protocol provides that if the court finds that there has been violation of our human and people's rights, it shall make appropriate orders to remedy the violation, including the payment of fair compensation or reparation. The court notes that, paragraph 15, the court notes that responsibility of the respondent state and causation have been established in the judgment on the merits, where it found a violation of the applicant's right to legal assistance guaranteed under Article 71C of the Charter. The court will therefore, against this finding, examine the applicant's claims in respect to other forms of reparation. On material laws, the court then, on material law, the court considered loss of income and life plan. In the instant case, the applicant does not prove how the respondent state's failure to grant him legal assistance during the proceedings before domestic courts has caused him loss of income, affected his life plan, and caused material prejudice to his wife. As the records show, prejudice caused by the lack of legal assistance did not indeed impact the proceedings before the High Court and the Court of Appeal, given that the applicant was having actually availed himself representation by recourse to the services of a lawyer. Furthermore, this court did not find that the conviction and sentencing of the applicant were as a result of the lack of legal representation, and that domestic courts did not uphold any of the fair trial standards, did not uphold any violation of the fair trial standards guaranteed in the Charter. As a consequence of the foregoing, the court dismisses this prayer. On course of proceedings before domestic courts, the court finds The court notes that the applicant does not provide evidence for the claim relating to costs incurred in the proceedings before the High Court and the Court of Appeal of the respondent state. The court considers that while it had found a violation of the right to legal assistance, such finding did not impact on the conviction and sentencing of the applicant in domestic proceedings. The said violation cannot therefore be said to exonerate the applicant from supplying evidence on costs allegedly incurred as a result of the said proceedings. The claim is therefore rejected. On non-material loss, the court, based on his earlier findings and the circumstances of the present case, awards the applicant Tanzanian shillings 300,000 for the moral prejudice suffered due to the respondent state's failure to grant him legal assistance. The court observes that in the instant matter, only the failure to provide the applicant with legal assistance was retained as the main prejudice from which the indirect victims can draw damage. The court notes that the applicant does not justify the said claims by the lack of legal assistance, but rather by his imprisonment, which this court did not find was in breach of any of his rights. As a consequence of the foregoing, the court finds that reparation is not warranted and dismisses the claims. On non-pecuniary reparations, restitution, the court notes that in the present case, only the failure to grant legal assistance was established and remedy duly afforded. Considering that this court did not find any other violations which caused prejudice that would warrant returning the applicant to his initial situation, the claim for restitution is not justified. On non-repetition to the violations and report on implementation, the court is, however, cognizant of the prospect of systematic violations, given that other users of the respondent state justice system may suffer the same violation. In this regard, it is worth noting that the respondent state has, in 2017, that is the year preceding the judgment on the merits in the present matter, enacted a Legal Aid Act under which assistance is provided to persons facing criminal proceedings. The court considers that the enactment of the Legal Aid Act has rendered redundant any subsequent order on provision of legal assistance to users of the respondent state justice system, save for an effective implementation of the Act. In order for non-repetition aimed at preventing systematic situations will therefore be relevant only when the court examines future requests for reparations involving implementation of the Act. As a consequence, the court does not make any order for non-repetition. On publication of the decision, the court knows that, as earlier recalled, the present matter involves only the failure to provide legal assistance towards which the respondent state had acted by adopting a Legal Aid Act in 2017. That is after the filing of the application, but prior to the judgment on the merits. It must further be noted that this court has, in other applications, issued several judgments related to the provision of legal aid, which it has ordered the respondent state to publish. Given that the present case does not involve a systemic violation and the judgment on the merits did not include a specific measure to be implemented by the respondent state, this court does not find it necessary to order publication of any of its judgments in the instant matter. Costs. The court notes that the applicant was duly represented by PALO through the proceedings under the court's legal aid scheme. Noting further that his legal aid scheme is pro bono in nature, the court rejects the claim. Other expenses relating to proceedings before this court, the court decides that each party shall bear its own cost. Operative part. For these reasons, the court unanimously on pecuniary reparations does not grant the prayer for material damages sought on account of loss of income, life plan, and the costs incurred in the proceedings before domestic courts. Grants the prayer for damages in relation to the failure to be afforded free legal assistance and awards the applicant the sum of Tanzanian shillings 300,000 and orders the respondent states to pay the amount indicated and subparagraphs 2, free from taxes within 6 months, effective from the notification of this judgment, failing which it will pay interest on arrears calculated on the basis of the applicable rate of the Central Bank of Tanzania throughout the period of delayed payment and until the accrued amount is fully paid. Non-pecuniary reparations dismisses the prayer for restitution, non-repetition, and publication, dismisses the prayers for reimbursement of legal fees. On implementation and reporting, orders the respondent state to submit to the court within 6 months from the date of publication of this judgment a report on the measures taken to implement the orders set forth herein, and thereafter every 6 months until the court considers that there has been full implementation thereof. On costs, dismisses the prayer related to payment of the costs and other expenses incurred in the proceedings before this court, orders each party to bear its own costs. Signed by the judges that I had mentioned at the beginning of the delivery of this judgment. Done at Arusha, this 25th day of June in the year 2021, in English and French, the English text being authoritative. Honorable President, that's the judgment of the court.
La Cour a ainsi décidé. Nous passons à la suivante affaire qui sera lue par l'honorable juge Chizumila, l'affaire Kijiji Isiaga. Honorable juge, vous avez la parole.
Thank you very much, Honorable President. This is the matter of Kijiji Isiaga versus United Republic of Tanzania. Application number 032 of 2015. It's a judgment on reparations. The court, composed of President Blaise Chikaya, currently sitting in for President Imani Aboud, Vice President Ben Kioko, Judge Rafa Ben Ashu, Susan Menge, Marie Teresa Mukamulisa, Tujilane Arachizumila, Chafika Ben Saula, Stella I Anukam, Dumisa Bin Sebeza, Modibo Sako, all judges, and Robert Eno, the registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, herein after referred to as the Protocol, and Rule 9.2 of the Rules of Court, herein after referred to as the rules, Justice Imani D. Aboud, President of the court and a national of the United Republic of Tanzania, did not hear the application. I now move to the brief background of the matter. In his application, filed on 8 December 2015, Mr. Kijiji Isiaga, herein after referred to as the applicant, alleged that his right to a fair trial had been violated by the United Republic of Tanzania, herein after referred to as the respondent state. when its local courts relied on contestable evidence to convict and sentence him. He also alleged that he was not provided with legal assistance in the domestic proceedings, despite him being lay and indigent. Subject of the application. On 9 May 2018, the applicant filed his written submissions on reparations following the judgment on merits rendered on 21 March 2018 by this court, which found a violation by the respondent state of Article 7.1c of the African Charter on Human and People's Rights, herein after referred to as the Charter, by failing to provide free legal aid, free legal assistance to the applicant. Prayers of the parties. The applicant prays the court to grant him reparations for the period he has spent in custody, calculated per ratio of the national income of each citizen of the respondent state. Alternatively, the applicant states that the respondent state may proprio motu take measures to release him from prison in lieu of the pecuniary reparations. On its part, the respondent state disputes the applicant's submissions on reparations and prays the court for 1, a declaration that the applicant's prayer for reparations has no merit for failure to meet the standards so required for reparations to be awarded. 2, an order to dismiss the application. And 3, any other order this honorable court may deem right and just to grant under the prevailing circumstances. Reparations. Article 27.1 of the protocol provides that if the court finds that there has been a violation of a human or people's rights, it shall make appropriate orders to remedy the violation, including the payment of fair compensation or reparation. In the judgment on the merits, the court established that the respondent state violated the applicant's right to a fair trial by failing to provide him with free legal assistance during his trial in the domestic courts, contrary to Article 7.1c of the Charter. Relying on the above finding of the court, the applicant prays the court to award him damages in the form of pecuniary and non-pecuniary reparations. On material loss, in the instant application, the court found in its judgment on the merits that the applicant's right to legal assistance under Article 7.1c of the Charter was violated. However, the court notes that the applicant neither specifies the precise nature and extent of the material damage he sustained, nor does he offer evidence showing that the prejudice was caused by this violation. In fact, the applicant simply describes his and his family's situation before his arrest without substantiation and without clearly stating the actual prejudice suffered. In any event, the applicant's general claims are based on his conviction, sentencing, and incarceration, which this court did not find unlawful. The court consequently dismisses the applicant's claims for reparations for material damage. On a moral prejudice suffered by the applicant, as indicated above, the court has already established in its judgment on merits that the respondent state violated the applicant's right to free legal assistance, on account of which he suffered moral prejudice. Accordingly, the applicant is entitled to moral damages. In assessing the quantum of damages, the court's practice has been that it grants applicants an average amount of 300,000 Tanzanian shillings in instances where free legal assistance was not availed by the respondent state, where the applicant was charged with a serious offense and where there are no extenuating circumstances. On this basis, and exercising its discretion in equity, the court awards the applicant the amount of 300,000 Tanzanian shillings as fair compensation on moral prejudice suffered by indirect victims. Again, as already stated above, the applicant does not explicitly pray the court to award reparations for his family members. The applicant has also not adduced documents proving his familial relations with any of his alleged family members. In this circumstance, the court does not need to consider granting reparations for indirect victims. For non-pecuniary reparations, the court notes that it has already dealt with this prayer in its judgment on merits, and therefore it does not need to pronounce itself again herein. Consequently, it dismisses the applicant's prayer in this regard. On costs, the court holds that each party shall bear its own costs. Operative part, for these reasons, the court unanimously on pecuniary reparations does not grant the applicant's prayer for damages for material prejudice. 2, does not grant damages for moral prejudice to the indirect victims, as the applicant failed to pray reparations for indirect victims and did not provide proof establishing his familial relations and alleged family members. 3, grants the applicant's prayer for damages for the moral prejudice he suffered from the violation of his right to free legal assistance and awards him the sum of Tanzanian shillings 300,000. 4, orders the respondent state to pay the amount indicated above, free from taxes, effective 6 months from the date of notification of this judgment, failing which it will pay interest on arrears calculated on the basis of the applicable rate of the Central Bank of Tanzania throughout the period of delayed payment until the amount is fully paid. On non-pecuniary reparations, does not grant the applicant's prayer for an order of release from custody. On implementation and reporting, orders the respondent state to submit to the court within 6 months of the date of notification of this judgment, and every 6 months until the court is satisfied thereof, a report on the implementation of paragraphs 3 and 4 of this operative part. On costs, orders each party to bear its own costs, signed by the bench that I mentioned above, done at Arusha this 25th day of June in the year 2021 in English and French, the English text being authoritative. Thank you, Mr. President.
Merci, honorable juge. La Cour a ainsi décidé. La suivante affaire concerne l'affaire Massoud Rajabou contre la Tanzanie, qui sera lue par l'honorable juge Chebeza. Chers collègues, vous avez la parole.
Honorable President, can I have a short adjournment as far as the reading of the judgment is concerned? Because I need to have a conversation with Grace about the areas which I should focus. I am sorry to do this to the Honorable Court.
Merci, chers collègues. On peut poursuivre avec l'affaire Ahaya Zumo contre la Tanzanie, qui sera lue par l'honorable juge Anoukam.
Merci, Mr. President. This is the matter of Yahaya Zumbo, Makeba, and 3 others against the United Republic of Tanzania, application number 023/2016. The court is as composed as in the earlier 2 judgments read this morning. So permit me to avoid repeating the same bench. The subject of the application, facts of the matter. It emerges from the original application that on the 10th of August 2012, the High Court of Tanzania, sitting at Tanga, convicted the applicants together with a co-accused who is not an applicant before this court of trafficking narcotic drugs, and they were sentenced to 25 years imprisonment each. The applicants were also ordered to pay a fine of Tanzania shillings 1,438,364,400 Tanzania shillings. Dissatisfied with the High Court's decision, the applicants appealed to the Court of Appeal of Tanzania against both their sentence and conviction. On the 8th of September 2015, the Court of Appeal dismissed the appeal in its entirety. Prayers of the parties before the African court, before this court. On the merits of the application, the applicants pray the court for the following. 1, a declaration that the respondent state has violated Articles 1, 3, and 7 of the African Charter and Article 14 of the ICCPR, the International Covenant on the International Covenant, and Article 10 of the UDHR. Secondly, an order to the respondent state to release the applicants from prison. Thirdly, in the event that prayer 2 is not granted, an order for the respondent to revisit the case and order a retrial. Fourthly, an order directing the respondent state to take legislative or remedial measures to give effect to the court's finding in their application. Fourthly, an order for cost. And sixthly, an order for such reparation as the court seems fit. In relation to provisional measures, the applicants pray the court for the following. An order that the respondent state shall not seek to recover the outstanding fine currently forming part of the applicant's sentence. Secondly, an order that the respondent state shall report to the court within 30 days of the interim order on the measures taken for its implementation.
Vous avez le micro coupé, cher collègue. Cher Anoukam, vous avez le micro coupé.
Janukam, your microphone.
Thank you.
Janukam, your microphone.
Thank you. I'll continue. That the application has not met the admissibility requirement provided by Rule 40, sub 5 of the Rules of Court. That the application has not met the admissibility requirement provided by Rule 46 of the Rules of Court. And finally, that the application be declared inadmissible and duly dismissed. As to the merits of the application, the respondent states praised the court to order that 1, the United Republic of Tanzania did not violate the applicant's rights provided under Article 2 of the African Charter on Human and People's Rights. Secondly, that the United Republic of Tanzania did not violate the applicant's rights provided under Article 7 of the African Charter on Human and People's Rights. Thirdly, that the application be dismissed for lack of merit. Fourthly, that the applicant's prayers be dismissed in its entirety. Fifthly, that the applicants continue to serve their sentence. And lastly, that the applicants should not be awarded reparations. After deliberation, the court formulated the following as the operative part of its judgment. Unanimously on jurisdiction, dismisses the objection to its material jurisdiction, declares that it has jurisdiction. On admissibility, the court dismisses the objections to the admissibility of the application. The court declares that the application is admissible. On merits, the court finds that the respondent state has not violated the applicant's right to equality under Article 3 of the Charter. Also on merit, the court finds that the respondent state has not violated the applicant's right to a fair trial under Article 7 of the Charter. Also on merit, the court finds that the respondent state has not violated Article 1 of the Charter. On reparations, the court dismisses the applicant's prayers for reparations. The court equally finds that the request for provisional measures is mute. On cost, the court orders each party to bear its own cost. This judgment is signed by the same bench and is done at Arusha this 25th day of June in the year 2021 in English and French, the English text being authoritative. In accordance with Article 28(7) of the protocol and Rule 70 sub 3 of the rules, the declaration of Justice Shafika Ben-Saula is appended to this judgment. Thank you, Mr. President.
Merci, honorable juge. La Cour a ainsi décidé. Nous allons revenir à l'affaire précédente sur l'affaire Massoud Rajabou, qui sera lue par l'honorable juge Tsebeza. Honorable juge, vous avez la parole.
Thank you, Honorable President. In the matter of Massoud Rajabu versus the United Republic of Tanzania, application number 008/2016. This is the judgment delivered by the court. The court is composed of Blaise Chikaya, Vice President, Ben Kioko, Rafai Ben-Ashur, Susan Mengwe, Madam Teresa Mukamulisa, Tujilani Chizumila, Shafika Ben-Saula, Stella Anukam, Modibu Sako, and Dumisa Nzebel. Robert Ino being the registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and in accordance with Rule 9, subsection 2 of the Rules of Court, hereinafter referred to as the Rules, Justice Imani Diabod, President of the Court and the National of Tanzania, did not hear the appeal. The subject of the application, I deal with the facts of the matter. The record before the court indicates that on the 21st of December 2009, the applicant, who was a tailor, invited an 11-year-old minor to his house for her to try out a gown that he had sewn. It is in the applicant's house that he was said to have committed the rape of the minor. This incident was later reported to the village chairman, who directed that the applicant be taken to the police station, where he was subsequently charged with the offense of rape on the 23rd of December 2009. On 8 April 2010, the applicant was convicted of rape by the district court at Tanda and was sentenced to 30 years in prison. Being dissatisfied with the conviction and sentence, the applicant appealed to the High Court of Tanzania, sitting at Tanga. The High Court delivered judgment on the 4th of May 2012, dismissing his appeal. On the 8th of May 2012, the applicant appealed before the Court of Appeal, which upheld the judgment of the High Court on the 29th of July 2013. On 6 August 2013, he filed a motion in the Court of Appeal for, quote, revision of his case, which was rejected on the 19th of November 2013. I now go to the prayers of the parties. The applicant prays that the court should find the violations of his rights and it should quash his conviction and set aside his sentence. In its response, the respondent state prayed the court to grant the following orders. 1, that the Honorable Court is not vested with jurisdiction to adjudicate the application. 2, that the application has not met the admissibility requirements stipulated under Rule 40, subsection 5 of the Rules of Court. That the application has not met the admissibility requirement stipulated under Rule 40, subsection 6 of the Rules of Court. That the application be dismissed in accordance with Rule 38 of the Rules of Court. That the cost of this application be borne by the applicant and that the application lacks merit. The respondent state further prays that the court should declare that it has not violated any of the rights alleged by the applicant. I then go on to the operative part, which concludes as follows. For reasons stated in the judgment, the court, 1, unanimously on jurisdiction dismisses the objection to material jurisdiction, declares that it has jurisdiction. On admissibility, court dismisses the objections on admissibility and declares the application to be admissible. On merits, the court finds that the respondent state has not violated Article 7, subsection 1 of the Charter as regards the alleged insufficiency of evidence. The court further finds that the respondent state has not violated Article 7, subsection 1 of the Charter as regards the delivery of the judgment by the district court in absentia. The court further finds that the respondent state has not violated Article 7, brackets 1, brackets B of the Charter in relation to the dismissal of the application for leave to review the Court of Appeal judgment. The court further finds that the respondent state has violated Article 7, brackets 1, brackets C of the Charter and Article 14, brackets 3 of the ICCPR as the applicant was not provided with free legal assistance. Consequently, on reparations, pecuniary reparations, the court wants the applicant's prayer for damages for the moral prejudice he suffered and awards him the sum of 300,000 Tanzanian shilling. The court orders the respondent state to pay the applicant the sum of 300,000 Tanzanian shillings, free from tax, as fair compensation to be made within 6 months from the date of notification of the judgment, failing which it will be required to pay interest on arrears calculated on the basis of the applicable rate of the Central Bank of Tanzania throughout the period of the delayed payment until the amount is fully paid. With regard to non-pecuniary reparations, the court dismisses the applicant's prayer for the quashing of his sentence and the order of his release from prison. And on the implementation and reporting, the court orders the respondent state to submit to the court within 6 months from the date of notification of the judgment a report on the status of implementation of paragraphs Roman law 9 and Roman number 10 of this operative part, and thereafter, the court orders that the respondents should every 6 months report until the court considers that there has been full implementation thereof. On course, the court orders that each party should pay its own cost. This done at Arusha on this, the 25th day of June, in the year 2021, in English and in French, the English text being the authoritative text. I hand down the judgment.
La Cour a ainsi décidé. Nous allons à présent changer de formation afin d'intégrer sur le banc la présidente de la Cour. Et cela va nous demander 5 minutes d'arrêt et nous allons revenir en direct devant vous. Merci.
Okay.